Hello, I'm Rick Schultz.
I'm Erin Schultz.
And welcome back to AudioFile. Today we wanted to go further into the world of patents, and our subject matter for today is?
Application process.
The application process. So, when you apply for a patent, I'd like to give you a little bit of background on what you're going to go through. And maybe I'm going to spend a little bit of time helping some of you that do have inventions yourself on what you might want to consider doing. There are two basic reasons to apply for a patent. One is to give your idea a tad of potential merit. Okay, because when you get a patent on something, it does qualify under the last two videos that we had, that the idea, according to the attorneys and engineers, or it might not be an engineer depending on what you're patenting, are actually a good idea. Okay, and a good idea in a matter of whose opinion in this particular case is going to be a very qualified professional. So the U.S. Patent Office actually requires that their patent officers are attorneys. Okay, and they must be attorneys that are approved at the bar at the highest state or court of that state. Okay, so I could be Supreme Court, I would assume, that they're talking about, but they have to be approved at the highest level or highest bar of that state. So that's quite a qualification. That means that the people that are actually working with your patent are highly intelligent, are highly qualified, and are going to be someone that you're going to have a challenge working with, because they're not easily snowed.
Yeah.
If you don't have your goods together, if you don't have a good idea, if you don't have something that's novel, if you don't have something that's non-obvious to someone skilled in the trade.
It's not presented appropriately, all of those things.
Yeah,
I'd imagine that there would be a number of checks and balances when it comes to processing.
Yeah, one of the things is that the terminology actually must be done in such a way that it is a legal mindset when you write. Okay, and because a lot of people who are looking for self-application wouldn't necessarily have a attorney's mindset, the U.S. Patent Office actually supplies help in that area. So if you want to do it yourself and try to save some money, you can get some help from the U.S. Patent Office. It's something that is written online. I've never actually looked into it to see what kind of help, whether it's videos or they let you talk with someone. I don't know what that help is, but they do disclose that they offer services in that area.
Okay.
Okay. And when you go to do a patent in the United States, they just recently changed the law that it's first to file. So if you've got a patent and you're not the first one to file it, you can't actually get a patent. Do you think there's any exceptions to that?
I don't know.
Okay, so like I covered in our last video, you still have to be the inventor.
Okay, so what would qualify you as the inventor? How would you prove that?
One of the ways is disclosure. Okay, so that's the primary way. Did someone already come up with this and put on a YouTube video that pertains to a technology, that is yours, and it can be found? So the U.S. Patent Office goes through a lot of work in trying to make sure that you're and you're responsible for this too, by the way. When you do a patent, you're responsible to make sure that you're not trying to patent something that's already been patented. And one of the things I see inventors making the mistake of doing is trying not to find out, because it's such a great idea and they want the patent so bad that they try not to find out if somebody already has this idea out there, thinking that if they didn't know about it, that'll help them to get a patent and they'll be covered anyways. The truth is that not only would they not be covered, but there's a potential that in litigation they could be fined double the amount.
Wow.
Yeah.
So there's an incredible amount of investigation and research that happens. There's
Yes.
not just an assumption made that, oh, well, because somebody's sending us this is what we have to work with.
Right.
They begin it with the actual research and investigation, of which we are responsible as individuals who submit an application,
Mm-hmm.
is to have a good idea. And does that mean, like, okay, if you missed it, you missed it? If due diligence is done?
Yeah, it
You know?
doesn't mean that your patent then in litigation would hold up in court. But if you really did your due diligence and you can prove that, the chances of you being fined double are much more slim than if it was just obvious that you really hadn't done your homework on it. If you just try to snow them over and that becomes at all obvious in a time of litigation, you're definitely going to go down for a big slam. And patent litigation, let me help you understand, is not an inexpensive thing. There's no possibility of ever entering into patent litigation with at least $1 million in cold hard cash up front set aside.
Yikes.
Yeah, it's extreme. It's the most expensive type of law in the world. So you definitely don't want to be in a situation where you get litigated over something that you're not confident about, because your chances of losing a lot of money are extremely high. However, not everybody that gets a patent really cares whether they're actually properly protected, and that's sad. But I've heard people talk about inventions and saying that they're looking to patent it basically for the accolades of getting a patent, and that doesn't really work either, because very rarely are those patents actually issued, and if somebody has already got this, that means that you're infringing on their patent, then they can sue you. So it's in your best interest as an inventor to make sure that you actually do have an original novel idea.
Right.
And if you aren't sure, you owe it to yourself more than anybody else to find out, because you're the one that's going to have to face the music in the end if it's not. So the application process takes, in our case, it took approximately a year to write the patent. It shouldn't take much longer than that, but it can take up to a year. And then to get an application, depending on how complex it is and in what field it might be. So in the area of computer engineering and chips, for example, it can be like 5 years before from the time that you're pending to the time that you actually get a patent. Okay, for most patents, you're looking in a time frame like from when you've actually filed to when you actually get an approved patent, about a year to 2 years. Okay.
Right. Okay. I know that there's kind of an assumption, or I don't know if it's an assumption, but an idea that, oh, this is just qualifications for the ego, often to have those patents. And I can attest to the fact that, all the investment, time, money, everything that goes into even applying for them, with the prospect, with the idea of using them in order to do business. It comes with a whole lot more, baggage than just the ego gets stroked from having a patent or being able to say, I have a patent. I don't know what the numbers of people who just do that thinking that that's going to be, or that they can criticize others for, oh, that's the only reason that you did it. Yeah. Really?
In the real world of patents, I don't know that has any real legitimate. You hear people talking about that really don't have any education on patents themselves and never really actually done one.
Right.
Once you get into the process, once you go to spend the money to apply, and you have taken the time to actually become educated, because you have to, about a patent, that just doesn't make any sense.
Yeah.
And the primary reason for that we covered in the other video, non-obvious to someone skilled in the trade. To get a patent, it must be non-obvious to someone skilled in the trade, which means that all the people that you're hoping to impress are going to come in thinking that your idea isn't a good idea in the first place. It has to be. So, without that qualifier from the U.S. Patent Office that your patent must be non-obvious to someone skilled in the trade, you come into a patent with the idea you're going to be humiliated, or you're
at
just
least challenged.
Yeah.
At least challenged.
Yeah. I think between challenged and humiliated has much to do with the character of the person that is bringing it across than it has to do with anything else. So there's people that just get offended, and they're so offended that they choose to try to humiliate. Yeah. And I've actually been in that situation a couple of times, and at the time couldn't even defend myself. I mean, I was asking them, hey, what do you think? And instead of getting back some creative and constructive criticism, I got back some comments that were designed to humiliate me and put me in my place. That I was not at all educated about this, and I didn't know my subject matter. And it wasn't until later that I learned how that also defined them. In humiliated them, and they didn't even know it.
Right.
And you know why that was?
We're complicated human beings.
We're complicated human beings, but that if it's supposed to be non-obvious to someone skilled in the trade, and someone sits on their laurels, I think, talking about how it's non-obvious to them. And how, because it's so non-obvious, you must be, kind of dull. Mm-hmm. That really qualifies them as to knowing a little bit less than what you did in the first place. Mm. Now, science, as it's defined, is the explanation of an observation. And what happens in a lot of these cases is you've come up with an observation, and through that you've managed to be able to explain it well enough to get a patent. And they want to come along with a technical explanation for why you didn't have the observation. Now, I'm going to cover this in a different video and go through it more thoroughly, but it's important for the subject matter of this video. If you have an idea because you've observed something, now this can be sonically, it can be visually, it can be anyway. You imagine Nikola Tesla or some of the great inventors of the olden days, taking and eliminating observation. So you remember we all kind of put in this idea in our minds of these inventors sitting in front of controlled observations, like a light bulb. Could you ever imagine inventing a light bulb without ever observing light come off a filament before?
Right.
Yeah. So
So
the observation is actually king. It's the centerpiece of science. Mm-hmm. And what happens is people instead, they take someone that has observed something and they try to explain why the other person couldn't have had the observation. And sometimes they'll use really complex terminology, and it sounds very intelligent, might sound like they're backed with a lot of science. Unfortunately, they've kind of abandoned science altogether. Okay, and the reason being is because that's the opposite of science. So science is the explanation of an observation. Science isn't licensed to tell someone that they couldn't have observed something because you don't understand it. Right? And in the U.S. Patent Office, when you're trying to get a patent, the people that are there are educated enough to understand that. Mm-hmm. So they don't come at it from that point of view, thank God. Could you imagine if they did? It would just be a mess. Nobody would ever get a patent. Mm-hmm. Eagle would be running amok in the entire, patent industry. And
sure. So then experimentation and checks and balances and all of those things come into play. It's not over one set of demonstration or observation. Then there's more and more, right? That's the whole basis behind awarding patents.
Right. You know, when it comes to observation too, I mean, it's important that it's controlled observation, that you can repeat the observation. So observation becomes key. Let's say, for example, I observe something, and I'm really interested in explaining it, and I want to, let's say, make a patent or something like that. Then my first responsibility isn't to start explaining it. My first responsibility is to observe it. So let's say I've got a guy that I think is not really qualified, that has come up with something, and he doesn't know what he's talking about, and I want to find out if there's any merit to what he's saying, but I don't think so. What's my responsibility as a scientist? Do you have any idea?
No, but I would guess to actually do it and repeat it, right?
Yeah, controlled observation is exactly it. If you fail to do that, you've failed science altogether. And all you can do in the end is babble. And no matter how technically you babble or how brilliantly you babble, the only thing that you can possibly achieve is babbling, is to go on at the mouth. Because you have given up that foundation of science and abandoned it in order to try to grab onto something else, which is all ego related, right? So often, if you didn't come up with the idea yourself, it can be offensive for somebody else that isn't as qualified as you think you are to come up with an idea that's better than what you might have,
sure,
or that's original, you know. And unfortunately, that all comes back to ego too. So the application process is one that is not based in ego. It's based in practical knowledge and skill sets of both law and in engineering or physics.
Okay, that's a good place to end.
Yeah. Well, thank you very much for joining us on this episode of the Audiophile. I do want to cover that one last, or the subject that I did on observation in its own video, so please catch that one when it's out. I'm Rick Schultz, and this is Erin Schultz, and we're out. Thank you very much. Bye.
Bye.